Hello everyone. In this segment, we will talk about contempt of court. To begin with, let's continue with the contempt of court definition. The term contempt of court is a genetic term descriptive of conduct in relation to the particular proceedings in a court of law, which tends to undermine that system or to inhibit citizens from availing themselves of it for the settlement of their dispute. The definition is given by Lord Cliq when he was giving the judgment in the case of Attorney General versus Times newspaper. This term contempt court can be easily understood as when we are disrespectful or disobedient towards the court of law, which means that we willfully fail to obey the court order or disrespect the legal authorities. Then the judges has the right to impose sanctions such as fines or can send the contemptor to jail for a certain period of time if he is found guilty of contempt of court. The term can also be understood in terms of freedom of limits of the judicial proceedings, as we know that all judges in the court can give judicial proceedings, which have a certain limit in which it has the freedom to make any judicial proceeding, and anything which curtails or stops it in making any judicial proceeding which is necessary can amount to contempt of court. Article 129 says that the Supreme Court shall be the court of record and it has all the powers of such courts, including the power to punish and contempt of itself. Now we should know about the meaning of contempt of record to understand why anything commented wrongly against a decision of the court leads to contempt of court. The answer is the court of record means a court having its act and proceedings registered for everlasting memory, or that memory which has no end and as evidence or proof. The truth of these records cannot be questioned, and also these records are treated as a higher authority. Anything stated against the truth of these records comprised contempt of court. Types of contempt of court. There are two types of contempt: civil contempt and criminal contempt. Section 2A of the Contempt of Court Act 1971 states civil contempt as willful disobedience to the order, decree, direction, any judgment or writ of the court by any person, or willfully breach of undertaking by a person given to a court. Since civil contempt deprives a party of the benefit for which the order was made, so these are the offences essentially of private nature. Defenses to civil contempt: lack of knowledge of the order, the disobedience or the breach done should not be. The order that has disobeyed should be vague or ambiguous. Orders shows more than one reasonable interpretation. Criminal contempt. According to Section 2C of the Contempt of Court Act 1970, the contempt criminal is defined as the publication of any matter by words, spoken, written, or by gesture, or by signs, or by visible representation, or doing any act which includes scandalize or tends to scandalize or lowers or tends to lower the authority of any court, biasness, interference, or tends to interfere with the due course of any types of judicial, obstructs or tends to obstruct, interfere, or tend to interfere with the administration of justice. Okay guys, that's it for today. See you tomorrow. Bye bye.